The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated and welcome. Let me also welcome the Professor Wright's students, international scholars, and LM candidates from the University of Iowa. I'm glad to have you in the courtroom this morning. 3 cases will be submitted this morning. Those cases are State of Iowa versus Martha Araceli Martinez. Second case is State of Iowa versus Maurice Angel. And the third case is State of Iowa versus Patrick Daniel White. Those last 2 cases are now submitted to the court without oral argument and will proceed to now hear the arguments in the Martinez case. Mr. Mears, you may proceed.
May it please the court, I am Philip Mears. I'm an attorney from Iowa City. I'm here representing Martha Martinez in this discretionary review case from Muscatine County. I do wish to introduce my co-counsel, Jack Hathaway, who is going to be appearing and making argument on behalf of the American Civil Liberties Union for part of the time allocated for us this morning. This is a fascinating case. It is a case which on some level is a case of first impression, perhaps in the country. The facts are very, very simple. Martha Martinez came to this country with her parents in 1999 when she was 11 years old. She had no immigration status. There are a number of people in that same situation. That she grew up in Muscatine, went to school there, and as a person without immigration status was not able to get a driver's license or an identity card, for example, from the Iowa Department of Transportation. So in 2003 and 2008, well, in 2003, she went and applied for and obtained Iowa identification card, not in her own name. She apparently submitted false information as to her identity, including a false Social Security card. She renewed that identification card in 2008 and proceeded to continue to grow up, be employed, have children. In 2000, but she lived to some extent in the shadows. That is, that she was not who her identification said she was. In 2012, the federal government announced a program that was intended to bring people like Martha Martinez out of the dark and to give them some status of some kind. It wasn't an amnesty. That was not able to be passed by Congress. It was an administrative action called a deferred action, DACA for short, Deferred Action for Childhood Arrivals. Under this policy, of which I think something like 600,000 or 700,000 people in the country have now taken advantage of, she was able to apply for some level of status. Wasn't technically status, and please understand I'm not an immigration lawyer, so I'm not entirely on top of all of the nomenclature, but that it was a form of, it was essentially a promise of sorts from the federal government that if she obtained and turned in this paperwork, she would not in fact be deported for some period of time. 2 years was the period. That she got this status, and one of the things that she was able to do with that status was get employment authorization. She got a Social Security card in her own name. It's temporary, only good as long as the status lasted, but imbued with some sense of hope she went in 2014 and applied for an Iowa driver's license. At that point, the Iowa driver's license computer, facial recognition software, what a wonderful term, determined that she in fact already had an identification card. The pictures matched. The Department of Transportation started an investigation, went and talked to her. She acknowledged that she had previously had a false identity card and had in fact been working under that identity. The Department of Transportation enforcement officer actually filed the initial complaint, and that was picked up by the Muscatine County Attorney's Office, who brought a trial information charging her with 2 different felonies, identity theft and forgery. There's a particular forgery statute that seems to specifically speak to this kind of situation. It is clear that she was being prosecuted for activity in applying for a job in the spring or the late winter of 2013.
It's not disputed she had, Mr. Mears, it's not disputed she had a false Iowa identification card, correct?
That's correct.
And do you dispute that Iowa has a legitimate interest in assuring the integrity of its driver's license and state-issued IDs?
Yes.
Mr. Mears, was any law violated?
In 2003 and 2008, when she applied for
When
those,
she applied?
probably. But those were...
Could they have prosecuted her under 715A21 for possessing a writing which the person knows to be forged in a manner specified in paragraph A or B without being subject to preemption?
Well, keep in mind the first set of questions were, could she be prosecuted? The second was whether any of this was subject to preemption. And that obviously our focus with regard to preemption is whether she can be prosecuted for applying for that job and filling out the I-9 paperwork using false papers.
Your position, I understand, is that's preempted. My question to you is, suppose the state had just decided to prosecute her for possessing a writing which the person knows to be forged, i.e. the Iowa identification document that was in somebody else's name. Would that be subject to preemption?
I think that many of the preemption arguments, even though not necessarily the conflict DACA argument, could apply as you move away from the I-9 paperwork. There seems to be some, the South Carolina case from the Fourth Circuit talked about the field in preemption of forged documents, and that suggesting that when you documents for individuals without status, there was in fact a federal field that created essentially a preemption zone. And so that I think that argument could have been extended, it seems to me, to simply possessing the false identification card. But that's not what she was prosecuted.
So in other words, if you were an unauthorized alien and you possessed a false identification, you could not be prosecuted. But if you were an American citizen, you possessed a false identification, you could be prosecuted.
That's correct. And even though that we can also jump ahead. I mean, the problem of creating preemption in a way, or using preemption in a way that shields certain groups but not American citizens is obviously one that Judge Whirling had difficulty with, is obviously a problem that the court in the Ninth Circuit, in the Arpaio case, had difficulty with. Let's just go ahead and get to that. It seems to me, first of all, that in dealing with preemption, you always have situations where some people can take advantage, if that's the right term, of preemption, other people can't. In the world of banking, which is about as far from my practice as a person could get, but I understand that there are federal banking regulations that apply to particular banks, that national banks, for example, that may not apply to other banks. That if a bank was prosecuted, or a person who worked for a bank was prosecuted in Iowa under state law, some people, if they work for a federal bank, may be able to impose a federal preemption defense, if it were. Because among other things, those people are going to be subjected to possible federal prosecution where maybe the other people weren't. So,
Raises another issue. Would you agree that if the government were able to prove that Diana Castaneda is a real individual and that your client knew she was a real individual, could she be prosecuted for federal identity theft?
I think so. But the point was that she would probably not have been, given the comprehensive and interrelated, I mean, the federal government, the Department of Justice.
Is there a statement from the federal government? Is there some, I understand DACA is an administrative program. You can look it up. It has certain criteria. Is there a criteria, a stated criterion of DACA that indicates that it's, you know, it doesn't matter if you've committed state identity theft, you're still eligible for DACA? Is there some, I mean, that's the question, kind of the question that your argument raises in my mind.
Well, let me try to address several of those points. That the DACA paperwork, and that's discussed particularly in the brief from the Amicus groups that filed a brief for the immigration groups, that does in fact talk about and recognize that people can, it is likely that people who are 23 years old and have been in this country for 12 years have in fact worked. And it is also likely that if they have worked, they may have worked with improper documentation. There is a recognition in the application process, for example, that a person may have done this before. And it is certainly the practice of the Department of Justice not to prosecute these cases, particularly with DACA-protected people. That is any of that in the record? I mean, we have references to the DACA application, some of the DACA documentation. Do we have a statement from the Department?
I mean, is there any kind, even if it's not in the record, is there some authoritative source that we can look up? Because the difficulty I have is a preemption based on just a general statement that the federal government is not pursuing this activity, that kind of a preemption argument, as opposed to some action that has the force and effect of law.
But whether they're going to do it or not, whether they're going to prosecute it or not, is a separate question. That could they, and if they have that authority, they're the ones that get to decide whether to do it or not some county prosecutor in Muscatine. That is, that one way preemption shows up is by a recognition that preemption, or that the statute in Congress has given the discretion to the Department of Justice and the people who, the federal people who enforce the federal immigration laws, to make those decisions about prosecution, and it's their call whether a prosecution will take place or not.
Counsel, has any court ruled that DACA itself, that a presidential or administrative order, preempts a state criminal law?
The closest that you get, I think, is that case out of the Ninth Circuit having to do with driver's licenses in Arizona.
I mean, ordinarily, we require a showing of congressional intent that is clear and manifest, and under our separation of powers. You know, the Congress writes the law, the president is to enforce them. And I'm just having trouble with the notion that a presidential executive order could preempt a state law.
Well, but I think the briefs contain significant references to the federal statutes passed by Congress that gives the discretion to the executive branch to make the decisions about who they're going to prosecute, who they're going to deport. The whole purpose of DACA is, the whole purpose of all deferred actions is a recognition that the executive branch has the discretion given to them by Congress to make those decisions.
Sure, but let me ask you this question. I mean, that's true in the enforcement of criminal law generally. I mean, let's take drug crimes. As we all know, there's federal drug crimes and there's state drug crimes. They overlap. The federal prosecutors have discretionary authority whether or not to prosecute somebody for violation of a federal drug law. Ordinarily, we say, I take it, that the federal drug laws don't preempt state drug laws. Why is your case different?
Because there's a recognition from the United States Supreme Court in the Arizona case that there's something special and something uniquely reserved to the federal government in the world of immigration law.
If we talk about Arizona versus United States, which I agree maybe ought to be the focus of what we look at, because that's the authoritative word, we're bound by that on federal preemption. The reason why the Arizona law in that piece of Senate Bill 1070 was preempted, that had to do with making it a crime for an unauthorized alien to work or seek to engage in work. And the Supreme Court said, well, Congress made a deliberate choice to subject people in that category only to civil consequences and not to criminal consequences. Here, I don't see that Congress made any such choice that somebody who doesn't just apply for work but applies for work under a false name should be immunized from criminal consequences.
So you start with the proposition that immigration law in its totality is federal, and that you have Arizona that says that just working cannot be criminalized by the state. And I might add, just working, Arizona was trying to criminalize work that would not have been authorized. There's a separate federal statute for call it identity theft or that forged documents. And that's where the Puente, Arizona case, the Ninth Circuit case, came up. And that case extended the Arizona case into the world of actual fraud in the application process, going beyond just working without papers. And that's why, I mean, I agree that the Supreme Court Arizona case did not address the fraud question that had to be presented in connection with the Arizona Arpaio case. And I might add that well, I also see, I have very little time left if I'm going to share that with my colleague, but that the problem with all of this is that immigration law, with its totality of regulations and in various agencies, that it is supreme, and that the state is simply not allowed to, I mean, the question is the state able to intrude into the world of prosecuting employment fraud in the application, particularly with the whole notion of the I-9 paperwork? I mean, the federal government has a statute, Congress passed a statute that said that the paperwork that you fill out in connection with the I-9 process cannot be used anywhere else other than in a federal prosecution. It can't be used in a state prosecution. And That's,
Ask Mr. Mullins about that.
Mr. Mears, thank you. Mr. Hathaway, would the bailiff place 5 minutes on the timer, please?
Thank you, Chief Justice, Your Honors, Counsel, and may it please the Court. My name is Jack Hathaway. I'm here for the ACLU. This case boils down to one thing. Muscatine County cannot have and enforce its own immigration law and policy. Arizona presents the test for preemption related to immigration matters that has been consistently applied by federal courts ever since. And under that test, this prosecution is preempted, and it's preempted in 3 ways. First, it's field preempted because there's a pervasive regulatory system for unauthorized non-citizens using false identification to work. Second, it's field preempted again because there's a dominant federal interest in exclusively regulating such conduct such that state prosecution on the same subject must be preempted. And third, it's conflict preempted because it interferes with core federal objectives related to foreign affairs, international humanitarian interests, labor rights, and it raises the specific conflicts recognized by federal courts since Arizona that arise with simultaneous state and federal prosecution related to immigration matters. Now, going to the first.
How do you explain the decisions of our of other state courts in Kansas and Missouri since Arizona versus United elected that position?
Well, the state cases argued by the parties, none of them addressed an as-applied challenge or a state statute that was clearly directed at regulating within the federally occupied field. And further, they're unpersuasive otherwise because none of them consider the scope of federal regulations or federal interests that are implicated with prosecutions of this kind. And going to those federal interests, the federal government clearly has the dominant interest in prosecution here. It alone has the plenary power over immigration, and it's used it to regulate unauthorized immigrant employment since 1986 through IRCA and the I-9 system. When deciding if and how to prosecute immigrants, it has to balance international humanitarian interests because of its responsibility for foreign affairs, which gives rise to its power over immigration in the first place. As discussed in Arizona, the country needs to speak with one voice when speaking to other countries about how it's going to treat their citizens. That's not 50 state voices, and it's not 3,000.
But Counsel, what about Iowa's interest in enforcing its own criminal laws against forgery and identity theft? Those laws apply neutrally to anyone, whether they're a citizen or a non-citizen. For example, I assume the Muscatine County attorney could prosecute an American citizen who got a fake identity to hide a criminal background so that he could work in a daycare center, for example, despite that he was convicted of child abuse. So what you're saying is Muscatine can only prosecute Iowans who are American citizens, but not somebody who is here without legal status. That just seems inconsistent to me.
Well, I think there's a couple ideas in there I want to unpack. The first one would be that regardless of the hypothetical applications that the state presented for how it could have applied the statute, that's not how it's applying the statute here, and there's an as-applied challenge raised on these statutes, raised under these statutes, that it is regulating in the federally occupied field of an unauthorized citizen using false identification to work. It's also worth noting that the remedies that were requested, they only go towards preempting the state from prosecuting within that very narrow field. It won't affect the state's ability to prosecute other aspects of identity theft or forgery. But getting back to the reasons why that field is federally occupied, it's because of the federal interests implicated here, but also because of the pervasive regulatory system that Congress has put in place. Through IRCA and the I-9 system, it's put in place 5 criminal penalty statutes, an extensive civil penalty statute, and 4.
The U.S. Supreme Court in Arizona versus United States did not say that even that the Arizona statute was field preempted, the one that made it, to the extent it made it a crime for an unauthorized alien to work or seek work in Arizona. They said that was conflict preempted because Congress had made a conscious decision not to criminalize that conduct. You're saying all that conduct is actually field preempted, right?
Well, when the U.S. Supreme Court in U.S. v. Arizona preempted 5C, they talked about the comprehensive system of regulation for that field. But yes, they did end up just finding it conflict preempted because of the congressional intent. What we're saying is that also within that case, when the court discussed the field of federal immigration registration, it presented the test for field preemption that applies in these cases. And the bases that were sufficient there was that it presented a full set of standards and that they worked as a harmonious whole. And you have that here with this field of federal regulation. You have an extensive series of criminal immigration and civil statutes, all of which cover the field of conduct such that there's no way anybody could ever act within it and not be subject to federal prosecution in multiple ways. And they all combine to make a harmonious whole. They're part of the I-9 system. They combine to make a complex prosecutorial mechanism through which federal prosecutors can precisely control if and how it will deter immigrants. For example, if they pursue under the civil penalty order statute, they can pursue just a cease and desist order, which will leave an immigrant open to a waiver of deportation under the corresponding immigration penalty, or they can pursue a civil money penalty order, which doesn't. And these are all buttressed by the provision that expressly preempts non-federal law enforcement from using I-9 documents.
You may sum up.
Okay. So because of these three bases of preemption and the fact that the state is applying them in this case within that field, this prosecution is preempted.
Thank you, Mr. Hathaway. Mr. Mullins, you may present the argument on behalf of the state.
Good morning. Pardon me. May it please the court. Well, the Attorney General's office welcomes this court's involvement in this admittedly new area of law. And as with any case, and perhaps possibly more, given the swell of public interest, concern as with any higher profile case, we care as much as if not more, how the court reaches its conclusion as the conclusion that it does reach. Because we seek guidance for local prosecutors in their choices as to how to protect Iowans and others from crime. And so, given that, I'd like to be sure that I cover at least three things. The first, that as to the forgery offense, we're talking about a facial challenge. And as to the identity theft, we're talking about an as-applied challenge. I would also like perhaps to underscore the areas of agreement that we share with the defense, as well as remind the court, if it needs reminding at all, of some important first principles. I think, looking from the opening briefs, that we're talking about a facial challenge to forgery. I understand that there's an interest in converting this to an as-applied challenge, and the Department of Justice has suggested that there may be a way to do so in the federal system. And if that is the case in the federal system, as far as an error preservation analysis goes, it is new to me. I won't dispute it as far as a matter of the federal system goes, but we're in state court now. And this claim is brought within state court as opposed to bringing, for example, a preliminary injunction in federal court.
What's the difference? Why can't we just do as applied for everything and let's cut to the chase and figure out what the law is? And we don't have the ultimate say here. The U.S. Supreme Court does, right? I'm hidebound enough to feel like I need to follow the rules, and if I'm told that I can't raise an argument that wasn't raised in the trial court,
I don't, or I try not to anyway. And so I think the state's arguments here admittedly are easier with a facial challenge, given the difficulties with that, that people face, because clearly we have a situation where U.S. citizens can engage in this conduct, and any 17-year-old that goes to the University of Iowa has likely contemplated carrying a false ID. I think it doesn't hold much water to say that we can only prosecute United States citizens for that conduct. That's not to say that the state can't also prevail on an as-applied challenge, both as to the forgery and as to the identity theft. Though I'll recognize that the task becomes more complicated.
I'd like to get into Arizona v. United States. Obviously, we're going to follow the United States Supreme Court on this issue, if it's a federal issue, and they have the ultimate say. And Arizona, at least, is kind of the most recent exploration of at least some of these issues. We're obviously involved with different statutes here, but I want to build on the point that was made by opposing counsel and get your response. And in United States versus Arizona, there was analysis of the federal registration scheme with respect to illegal immigration. And the Arizona court held that there was field preemption with respect to the registration scheme. Clearly, we're not dealing with registration in this case, but the suggestion is that the analysis that was used by the Supreme Court in Arizona, if applied to the forgery statute and the identity theft statute, would lead to the same result. And I want to give you an opportunity to say, no, that's not right.
No, that's not right.
And tell me why.
I think it's because we can legitimately look at Arizona as stating what it does say, that the states have no business in criminalizing the attempt at becoming employed in Iowa. But I think that as the later cases have borne out, Congress, consistent with the traditional recognition of the states' rights in pursuing crimes which have a more, shall we say, direct effect upon the other people in the community, to say that in those, I don't think that, I think the later cases indicate that once you do get further away from the effort at obtaining employment, then we are less and less likely to see either field or conflict preemption.
Well, with respect to federal registration, again, a different issue, but the court in Arizona said, well, look how comprehensively this is regulated. I mean, right? And yet with respect to I-9s and employment and so forth, the argument at least is raised that there's kind of a comparably dense field of regulation. Let's just stop there. Is that correct, or do you think that the regulation of employment identity theft is less dense than was the case in federal registration?
I can grant that the immigration, not identification, the immigration, the registration and the I-9 process is labyrinthine.
Okay, so that takes you kind of halfway down the analysis in the United States versus Arizona, it seems to me. Does it not?
It does. However, I think we can also recognize that, or at least I believe we can recognize that notwithstanding the complicated nature of going through registering in order to get a job, if you do so in a harmful way, take it, for example, a violent way, maybe, I find it difficult to believe that Congress has decided that it will take on the task for itself of...
Crime of violence, interesting. That's not quite what we have here, I don't suppose.
Not at all.
Right?
No, and I don't for a moment suggest that. But what I am saying is that if a person, for example, possesses fraudulent documents, there's a stack of fake IDs in the basement. That's assuming that you've got proof of intent to defraud, that's a forgery, okay? Now, the posture that we find ourselves in now is a little peculiar, and as with any initial, any claim that comes so early in the process, it poses difficulties for this court because we don't have much in the way of, well, in other words, this trial could be very different once it gets going, because the prosecutor, for example, could elect to amend the trial information, and assuming that everything else checks out, they could say, we're prosecuting her for possession of these forged documents, up to the point at which she used them to
Are you
obtain this
suggesting
job.
the claim's not ripe at this stage, that we ought to have further proceedings below or further fact-finding below? I mean, it strikes me that we have a pleading, and then we have a legal challenge to the pleading. And we should rule as a matter of law. But is that framework not right? I mean, do we need further factual development below before we hit on this preemption issue?
I think the court can reach the issues that are before it now. Of course, what I'm saying is that the court can and should, as it always attempts to do, tread carefully, because it could turn out that, well, for one thing, that the problem here, if the court concludes that there's difficulty with the act of seeking employment, and that's preempted, that doesn't mean that she still didn't commit forgery on the way to the Human Resources Office by carrying these falsified documents.
Well, let me follow up on that, because that seems to be, this is the issue that Mr. Mears raised. 8 U.S.C. 1324A says the I-9, and then it says, and any information contained in or appended to such form may not be used for purposes other than for enforcement of this chapter. Now, as I read Mr. Mears' brief, he's not saying there's express preemption based on that provision. And as I read, there's a Minnesota case, and I think there's a Kansas case. They seem to say that's kind of an evidentiary rule. You can't use the paperwork that the employer actually has in their, the I-9 paperwork that the employer actually gets from the prospective employee. But it doesn't at least those courts say it doesn't preempt the presentation of false documentation to the employer. Where does the line draw, and what's the reach of that statute?
I tend to think that that language in 1324 does not intend to swallow up the entire buffet of possibly forged documents, because these kinds of documents that might be appended to an I-9 include a state of Iowa issued birth certificate. And I would be surprised, or even, for example, a high school transcript or a report card, because they too can be appended to an I-9 application. And, you know, heaven help my son if he goes into the principal's office and learns that it's a federal offense to turn that B into an A, just because he wants to get a free rental at Family Video. So I think as a technical matter, the prohibition is likely evidentiary. I tend to disagree with the notion that is taken by the Department of Justice that it is not only an evidentiary bar, it's a prosecutorial bar, and it's even an investigatory bar. I think it is just what it says it is, that you just can't use the I-9 itself and the copies that are attached to it. But if it turns out that the Department of Transportation also has copies of these forged identification documents, the prosecution can use those for the actions that she committed while using them.
Let me explore another issue in Arizona, and I'm just going to read part of the opinion to you, and let's work on it. But again, we're not talking about the identical issues, but we're talking about here in Arizona the process of removal of immigrants. And the court says, among other things, by authorizing state officers to decide whether an alien should be detained or be removed, This violates the principle that the removal process is entrusted to the discretion of the federal government. And I'm trying to figure out exactly what this means. But part of the argument that they're building on, I think, is that, well, there's prosecutorial discretion, of course, in the federal criminal scheme, and there's prosecutorial discretion in immigration laws generally. I mean, that's clearly true, I think. And the suggestion, building on this Arizona quote that I have, is that, well, under the immigration laws, Congress intended to vest enforcement discretion, if you will, with the federal government. Now, we're not dealing with removal, so I'm just raising the analogy, but the suggestion is that federal authorities should have prosecutorial discretion, and shifting prosecutorial discretion to state officers is field preempted. I mean, that's kind of how it goes, and I want to give you an opportunity to explore the edges of that or explore the heart of it and give us some guidance.
Okay, so the way that I look at, or at least the way that I think of your question, is that it builds upon a premise that, as of course this is a first principle, that it's only the federal government that can get to decide as a matter of discretion who gets removed. Okay, so it's within the context of the removal power, which is to say also the immigration power that the United States government provides, that then that reasoning applies. Now, the reasoning that you mentioned, I think, has less force when we're taking it out and we're considering state criminal actions. Because I think we all have to know and understand that the web of criminal law can ripple out. And that's why, for example, in guilty plea cases, under Padilla, there has to be a mention to the defendant of the potentiality for immigration consequences. But that doesn't convert guilty pleas into removal proceedings, even though we know there may be some consequences that flow from it that impact the immigration relationship. So I think perhaps the question that you'll need to resolve for yourselves is, what's the extent of attenuation between the actions of the state actor and the immigration consequences?
Let me, at least in my mind, I somewhat separate, and maybe you do as well, the identity theft and what would be kind of a lower level forgery, a misdemeanor forgery, from the felony D forgery that's at issue here, because the felony D forgery statute came about in 1996, and looking at the legislative history, it does appear that the legislature was really focused on folks that were working without authorization in the state, with documents that were false or fraudulent in some respect. Now, why isn't that specific effort preempted, even if one could say that general identity theft or general forgery law is not preempted?
Well, the Ninth Circuit has covered that ground. I don't deny the interesting nature of the legislative history. That the Iowa legislature may have wished to reach the exact same conduct that Congress wished to reach, but that's different. What the Iowa legislature thought or thinks of doesn't probably hold a whole lot to what Congress intended. So if Congress intended preemption, the discussion's over. If Congress did not intend preemption, the fact that Iowa thought that it could reach unlawful employment, doesn't matter a whole lot. But I recognize that of the two, that's the first of two difficulties that the state's position faces. One is the expression of the legislative intent, and the other is the verbatim quotation establishes the D felony. It's the same language that's used in Section 1564. So I think again, relying on first principles, I think what we can understand from that is that Iowa's intent, the legislative intent, is not determinative. And the fact that we've decided to include documents that also serve a federal immigration function in those list of documents that we wish to protect in order to fortify the security of our financial system or our lending system, any of those other things, the fact that we have done so does not overcome the first principle that this is a criminal matter, and this is a criminal law. But that does fold into another argument that the local prosecutor raised, which is that there's reason to think that Congress may have contemplated these kinds of prosecutions in their definitions of an aggravated felony, because they include state forgeries or state identity theft convictions. Now, I'll recognize that I've only seen one federal case that references a state forgery of immigration documents. But at least, so it's sparse, to say the least, but structurally, it's there. So if structurally you can make that claim that there's some congressional cognizance of the possibility of state enforcement of forgery provisions or identity theft provisions, notwithstanding their attachment to the I-9, then I think we begin to see a clearer picture that these are not federally preempted.
Strike me that the argument they're making is kind of a tightrope. If they're arguing on the one hand that this state prosecution should be preempted because she'll lose her eligibility for DACA, well, if everything else they're saying about DACA is right, federal government shouldn't care about this state prosecution, right?
We're all walking a tightrope here. I think I can generally agree with that proposition, but it does bring to mind the more troubling idea that the act of prosecutorial discretion, if you want to call it prosecutorial discretion, by the President of the United States raises a question that I've not found any satisfactory answer, other than the oblique reference in the United States Supreme Court that it's questionable whether the president or whether an act of executive discretion can override congressional intent and therefore preempt a state prosecution. I have no further comments. Unless the court has questions, we respectfully request that this court affirm the district court's decision. Thank you.
Mr. Mullins. Mr. Mears, you may present your rebuttal argument.
So much to say, so little time. I'll try to bullet point it. First of all, the question of facial versus as applied, on some level at this point I don't care. What I mean by that is that in order for Martha Martinez to be able to maintain her status as a DACA person, she can't be convicted of any felony. So that she has to win on both of these. And so on some level, the statutory discussion about the forgery statute is interesting. She's got to win on the as-applied.
It strikes me that there's sort of an inherent as-applied aspect to this case because you have a real client with a real prosecution in front of you. This isn't like Arizona or South Carolina where it was an injunctive challenge by the U.S. Justice Department to a state statute, right?
Correct. So the real question is, can she establish an as-applied claim of preemption in this case? Back to sex offenders. I can't imagine why I would be attracted to this notion, but that it is a problem that Judge Whirling had, it's a problem the Ninth Circuit had. A couple of quick responses. First of all, I believe the United States said in their amicus brief in the Arizona Ninth Circuit case that if in fact you were prosecuting the sex offender for having forged the paperwork in connection, citizens fill out I-9 paperwork, or I guess the citizens have to submit paperwork under the I-9 regulations too. And if a sex offender submitted forged documents in connection with his or her I-9 paperwork, that could very well be barred by the federal statute that prohibits the use, whether that is the 1324A argument. Secondly, the sex offender doesn't have access, isn't going to get deported if the person's a citizen, if it turns out wrong or the prosecution goes through. The sex offender is not subject to the myriad of federal regulations and laws governing his immigration status. That's unique to the non-citizen. That field preemption, there is been discussion about field preemption. And the comment about the Arizona case that Arizona did not involve field preemption on the employment statute is correct. It was conflict preemption. But that's why in the progress of cases, you go from Arizona to South Carolina to Arizona Puente, and those cases take you beyond the statute in the Supreme Court Arizona case to the point where you're dealing with fraud. The South Carolina case specifically dealt with the South Carolina statute, which made it illegal, unlawful, for a person to possess a false or counterfeit ID for purposes of proving lawful presence. The Fourth Circuit said, extending Arizona to its situation, that was field preempted.
Like an alien registration document. That's
talking about possessing
not a state ID would not be such a document. That doesn't prove, at least in the view of the federal government, that doesn't prove I'm lawfully in the country.
I don't think of that as a registration document the way it was at issue in Arizona. That's not certainly how the analysis. That was more going to the counterfeit or false ID, which wasn't present in the Arizona case. And that, what was Martha Martinez prosecuted for? At the argument, the county attorney said she was prosecuted for uttering these false documents. She's being prosecuted for the paperwork that she turned in connection with her I-9 status. That's what she's being prosecuted for. And that's preempted. Among other things, you've got the very specific 1324A statute. Somebody said, well, you're not really arguing express preemption. The Kansas case, and it just came down 2.5 weeks ago, that was interesting because it seemed, first of all, it's an as applied, the lawyer argued as applied as opposed to on its face to challenge the Kansas statutes. But there was also discussion in that case and recognition by the Kansas appeal courts that you couldn't prosecute somebody in Kansas in connection with the I-9 paperwork. And and they almost go so far as to say express preemption because of this statute. It's certainly, if it's not express preemption, it is strong evidence of field preemption, the field being fraud in the employment of non-citizens. I have to close with some notion of coming back to the DACA statute, or the DACA process that President Obama put into place. Congress has specifically said that the executive branch has the authority to decide who's going to get to stay and go in terms of deportation. And that deferred action's been around for a long time, not just for childhood arrivals. And that the problem with this prosecution is that when a person under DACA, you're supposed to go get a driver's license. And if in fact you have worked, and gosh, can you imagine, I mean, people work, they have to survive, support their families. The way to do that in an I-9 world is to present false information. And that this prosecution threatens the very process of that DACA program, whether it's expanded or not, depending on whatever happens in the next few years. guess that's, that's all I have to say. Martha Martinez was prosecuted in connection with applying for work in Muscatine using forged documents. She was prosecuted for identity theft and forgery. We believe that these are preempted in some form or another as applied to this prosecution. Ask your consideration of this very novel issue.
Mr. Mears, thank you as well, and we thank both counsel for your helpful arguments. The case then is now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.